we go. All right, because I'm sure I have a number of people that are left hanging because I'm trying to put so much information in a short amount of time. So we've been talking about rights acquired, and we're talking about a blank endorsement pursuant to 3205. And yes, the banks are correct. They've acquired rights, but rights to the note are not rights to the security instrument. Because they claim it is a blank endorsement, they've acquired the right to receive payment. But those rights to receive payment do not to the security instrument. Because in order to have a properly perfected lien, there must be a properly named party. You cannot properly perfect a lien without having a named party. If I want to go and transfer the note correctly, I would put whose name I'm going to transfer the note into. So when I did my assignment, I named the party that that tangible promissory note is reflecting. So the beneficial interest goes from A to B, not from A to an as of yet unknown party. So let's take a look at, this is an infographic, a number of them that we have created. This is not something that any other company has come up with. A while ago, my partner Damian Emholtz had a suggestion, and that was that in order to show people visually what was going on, because not everyone has the capacity to understand everything that is spewing out of what we're talking about on the webinar at one time. And I understand this is like drinking water from a fire hydrant. So I'm going to try and slow it down so that we have an understanding. So, in this particular infographic, so this is a visual representation of what was to take place on the left side as required by statutory requirements of law, and then what actually happened on the right side. And you'll notice that they don't look the same. And in this particular one, they don't have MERS. All right. And then I'm going to show you a couple different ones with MERS, without MERS. So let's start out with the top. And we're going to start with the left side over here. So what we're going to do is this. So here we go. At the top, we have Jane Doe. Jane Doe signed at closing. Here's the closing date, July 6, 2005. Now, when she closed that, on the same day, she signed a note and a mortgage. That mortgage, as a security instrument, was sent into the county recorder's office, where it was indexed, filed, and recorded. All right, and then it was sent to the originator. All right, now the originator then takes this and he says, I need to do a sale. Someone wants to purchase this. Okay, so we have through endorsement, transfer, delivery, and negotiation, all right, he sells the note. It is properly endorsed, paid to the order of, and he names the party without recourse. And the reason they do without recourse, it is without warranty, without limitation. So when you take it, they no longer have any claim to it. It cannot, there is no takebacks. It's yours without recourse. All right, so then the originator says, I'm going to sell it. And when he does for negotiation, transfer, and delivery to the sponsor seller, it was New Century Credit Corporation. All right, at the same time, he had the mortgage, which went down into public record, where it was recorded, indexed, filed of record, properly perfected, sent, all right? Now, when the sponsor seller has it, they say, hey, you know what? Money off this, I want to sell it. And it's transferred by an endorsement, negotiation, transfer, and delivery. And so the note, again, went from sponsor seller to the depositor. The depositor was New Century Mortgage Securities, LLC. And when the sponsor sold this, they also did an assignment of mortgage, filed it at county recorder's office where it was filed, indexed, recorded, and then, again, we have a properly perfected lien. Now, if you notice this whole time, we have this little circle here, all right, and it says payment obligation. I promise to pay. And if you notice, it follows. Every time there's a sale of the note, all right, this is a complete instrument. The obligation, the note, and the mortgage. So every time this follows completely. All right, so now the depositor gets it. Right? Again, remember, we need to have a minimum of 2 transactions out for this to be bankruptcy remote. And the reason it's bankruptcy remote is so that they want to protect it. So it is a proper procedure that must be done in order to have sale. It must be 2 transactions out in order to be a RMIC. It must be bankruptcy remote. All right, so now the depositor, New Century Mortgage Securities, LLC, decides that he's going to sell to the trustee, all right, which is Deutsche Bank National Trust. And he does this pursuant to negotiation, transfer, and delivery. So he sells the note along with the obligation to the trustee. At the same time, we have the mortgage. We have an assignment of mortgage recorded into the county recorder's office where it's indexed, filed, recorded. We now have a properly perfected lien. The trustee then has this and he says, oh, okay, then this is going to go into the trust now because the trustee, just naming a trustee does you no good. Trustee for whom? Well, the trustee has to name a trust. In this case, it is the NCHET Trust 2005-4. Okay, so he's going to do through transfer, negotiation, delivery, all right, to the trustee, to the trust. And this is to be done prior to the closing date of October 17th of 05. That is what is to be done in accordance with law. All right, now, again, they signed July 6th. The closing date is August 17th. So even if we gave them an additional 30 days, they would have till September 17th of 2005 to get this in. And again, many times they even give them 90 days. It just depends on the trust. So even if we gave them 90 days after August 17th, we would have, by November 17th of 05, all of these transactions would have taken place. And it would have been close, but it could have been done. All right, so now let's look at what was actually done. All right, so now we look at what was actually happened. Okay, we've got the borrower, Jane Doe. All right, she signed at closing. We have the note and the mortgage. All right, right after closing, it went to the county recorder's office, and it was filed, indexed, and recorded, and we have a properly secured lien. All right, now, when the originator gets it, all right, he scans it into whatever digital format he wants. All right, whether it's using IBM or whatever. They all have different systems, but it's stamped then with an as of yet unnamed payee, and then many times they either destroy or mutilate or shred the tangible promissory note. And I can tell you that in the state of Florida, there is even a case that was filed where the mortgage Bankers Association from the state of Florida stated that they do destroy and shred all of the tangible promissory notes after it's recorded into public record. When they get it back and they scan it in, they said that we destroy them. Now, sometimes it is vaulted too. But what also happens is that this payment obligation we had here, all right, is stripped. It's stripped from this tangible promissory note. This payment obligation, all right, which is the transferable record that they take, all right, and they sell this. Now, the intangible payment obligation is stripped and transferred electronically with the push of a button. Now, once they've done that, that Doe note is no longer eligible for negotiation. All right, pursuant to Uniform Commercial Code 3203D. Why? Because transfer of less than the entire instrument. All right, you're selling just this payment obligation. You don't have the whole instrument. Without the whole instrument, you have not transferred the entire instrument. So we've got the sponsor seller, New Credit Corporation, New Century Credit Corporation. They've got this intangible payment obligation, this intangible payment obligation to the depositor. The depositor is New Century Mortgage Securities, LLC. Again, we don't know what has happened to the note. That's why this arrow here shows there's an unnamed party, as of yet unnamed party. We don't know who the payee is. It's not named. All we know is that this intangible payment obligation is going from party to party to party. All right, the depositor sells this intangible payment obligation to the trustee, Deutsche Bank National Trust Company. Deutsche Bank National Trust Company sells that intangible payment obligation electronically to the RMBS Trust, NCHET 5-4, and they do it prior to the closing date of August 17, 2005, because that is the last day in which the trust can acquire its assets. Again, the assets being the transferable records, which fall under Article 8, not Article 3. All right, so what has happened? All right, usually this note, it says, does not arrive at trust. It's often vaulted or destroyed. Okay, so over here on the right-hand side, this light yellow, okay, you can see it evidences that the Doe mortgage is no longer secured to the tangible note. Why? Because the debt was stripped away from it. So we don't know if that paper note was possibly transferred in negotiation. There is no assignment in record to memorialize the negotiation for that note to an as of yet unnamed party. Now, these are assignments, and if we just do 1 second, here we go. So I'm doing a side view to show you these are 2 assignments that were done. And we reference the assignments in our investigation and analysis that we do pertaining to chain of title. So this states, upon loan default, documents purporting to be assignments are recorded. The purported assignments transferred nothing, as the intangible payment obligation being has already been stripped from the tangible promissory notes. These recordings of assignments do not memorialize the sale or negotiation of the tangible note. Again, you can collect payments to the note. However, rights to collect through the blank endorsement of the note do not extend to the security instrument, which is to evidence the debt which has been sold. So that is the illusion that is given. Now again, this one doesn't have MERS. What we will do is let's go through and let's see what happens when MERS is involved. All right, so bear with me for 1 minute. Okay, so here we go. Give me 1 second. Oops. 1 minute. Okay. 1 second. I've got so many charts here. Let's see. Sample. See if this is it. 1 minute. Okay, that doesn't. Okay, 1 minute. I'm sorry for the delay, people. I want to bring you up an actual one that we can do. So let me just go into, here we go, we'll go to Jesse's. Okay, that's Fannie Mae. One second. I want to show you an RMBS, and so I just need that. Yes. Okay. Using MERS. Okay. Okay, so let's see. Okay. All right, so just trying to pull up an RMBS with MERS. So I just need another minute. This is a infographic pertaining to a GSE. A GSE being a government-sponsored enterprise, being Fannie Mae, Freddie Mac, or Ginnie Mae. So if you take a look at this for 1 second, and let's do, all of these are all filled in. Here we go. Infographic with MERS. All right, so we're going to complete the RMBS, then we'll get to a GSE. All right, so we went over the RMBS showing without MERS. I'm going to show you now an RMBS loan, residential mortgage-backed security, using MERS. All right, so using MERS, what has actually happened? We have the borrower, John Doe. We have their signing. So we have the note, the obligation, and the mortgage. So after signing, the mortgage goes to the county recorder's office, where it's indexed, filed, and recorded. All right. Once that happens, we now have a properly perfected lien for the note and the mortgage. All right. Now, after that, after it comes back to the county recorder's office, all right, the then paper note is scanned into the system and stamped with a payee unnamed, and then it's often vaulted and destroyed. And at that time, the note is no longer eligible for negotiation because that intangible payment stream is stripped out and sold. Now, understand, when we're talking about the note, we're talking about the tangible promissory note. So now when we talk about the tangible promissory note, and they're coming forth to collect under a blank endorsement, we're talking about the note. We're not talking about rights acquired to enforce. So 3205 says, hey, I've got it. It's a bearer instrument. All right, okay. You can collect on the payment stream, but you have not acquired rights in accordance with law to foreclose, because with an as of yet named party being named, you cannot perfect a no name to a mortgage instrument. You must have a named party. You need agent-principal relationship. So we're talking about, again, two different things, the notes and the security instrument. When we look at here where the intangible obligation is stripped out, and this intangible obligation is sold to a sponsor, seller, sold to a depositor, all right? Now, the minute that happens, purple lines go to MERS. These purple lines reflect the transferable record, the promise to pay. So anytime servicing rights or that transferable record changes hands, MERS is given that information. And that is the reason for all these purple dots. Every time there's a transaction pertaining to MERS, the transferable record, MERS is notified. Notifying MERS, all right, MERS is a separate database. MERS is not the same as public record giving constructive notice to the world as to what has taken place. So we're talking about two completely different things. Putting this into MERS, all right, this is a private database. MERS does not and cannot assign any rights that MERS has never. All right. So when we look at these purple lines, these pertains to transactions from the sponsor to the depositor. All right. Then from the depositor to the mortgage registration systems. All right. From the depositor to the trustee. All these transactions are marked. One of the interesting things to look at is this. MERS in its own documents claims, all right, that they cannot do anything, that they're just a database. So when we look at, give me 1 second. Okay. I'm going to show you in MERS' own words, so I'm not making any of this up. Let's take a look at, okay. Give me 1 second for this to open up and populate. Okay, so here's my source. Here's one of my sources. All right, so we're going to go to the MERS Procedures Manual. Okay. I don't mean to jump around, I just want to show you where the information is coming from. Okay, and then MERS is also okay. This is under MERS Terms and Conditions. Okay, sorry for the blurry copy, but it says MERS agrees not to assert any rights. MERS and the members agree that the MERS system will creating or transferring beneficial interest in mortgage loans. So MERS states that we don't have the right to do any of this. We can't do any of that. Now, okay, anyways, it's on page. So here is the actual, here it is. Okay, so I'm going to blow this up a little bit so you can read with me. So look at the overview. Although MERS tracks changes in ownership of beneficial rights for loans registered on the MERS system, cannot transfer the beneficial rights to the debt. The debt can only be transferred by properly endorsing the promissory note to the transferee. Again, this is off of MERS' own information. I've taken it right out of their book. So again, when you look at page 70, I've got all the manuals in front of me. I've got their PowerPoint presentations. I read them. I've gone through it. So they're saying the debt can only be transferred by properly endorsing it to the transferee. So when we're looking at this, again, we've got the note with again, the obligation, intangible obligation has been stripped out. It's over here. The note, we don't know where the note is. It's in Timbuktu. However, attorneys and homeowners are given the misconception, Joe, they sold my note. How do we know? Joe, they did an affidavit, and this person attested they've looked at bank records, and they said that my loan is in here. That's a hearsay comment. That's a hearsay claim. Because the only way to show that your tangible promissory note has been into the custodian is to subpoena the custodian. I'd like to see the records pertaining to the tangible promissory note. Because the custodian then is to have the records. What date did you have the records? Everything is in the collateral jacket that pertains to this loan. But having the note and having a transferable record of an asset is two different things. So when you look at MERS, all right, if you look at a MERS milestone report shows tracking of the beneficial interest and the servicing rights. When you look at, let's take JP Morgan Chase, and JP Morgan Chase says, I've acquired assets of WAMU. But what they don't tell you is WAMU sold those assets to this Washington Mutual Trust or to Fannie Mae or to whomever years prior to JP Morgan Chase acquiring the rights to service those loans. So acquiring rights to service those loans and acquiring a right which has been pledged already as an asset over in your left hand are two different things. The security instrument, all right, does not extend to an as of yet unnamed payee. It cannot. If you go out riding and let's say you're out and when you're outside you see a car that's running and you jump in the car and you take this car, all right, is it your car? Can you go sell this car? Well, I mean, legally, let's talk about it. You have possession of it. Okay, you're driving, I've got the keys. You don't say they were left in it, but let's go sell it. Legally, let's go to a car dealership and sell this. They're going to ask you, is the title in your name? Are you named to title? Have you acquired rights in accordance with law? No. Oh. So you just want to sell me the car, but you're not going to give me title. Well, I want to sell you a note, but I can't give you the rights that go with it. It is word crafting at its finest. When you understand that these are different animals, these are apples and oranges. Assignment of mortgage and assignment of deed of trust versus simple possession of the note. Apples and oranges. Did that assignment of mortgage or did that assignment of deed of trust memorialize the transaction pertaining to the sale, negotiation, transfer, and delivery of that note along with the acquisition of rights. No. And when you look at these affidavits that are coming out where it says, I am vice president in charge of bank records, I have looked at my computer screen and I have seen that note is in default. All right? When you look at that, right, that bank record does not reflect that that trust has had possession of that note. Hello? How does looking at an electronic record, which is a copy of a copy of a copy, the only way that note is evidenced into possession, right, is by somebody, right, from the custodian of record saying, hey, I've had it here. It came into my office on this date. Looking at a screen in front of you, say, I looked at the business records, and yeah, the trust has had it. I see all the payments that it made. I see all the money that went into it. But receiving payment from you for an intangible, not the same as receiving this tangible promissory note in accordance with law. Two different things. Because if this party that is given this affidavit is attesting to these records cannot show how she has firsthand knowledge how this trust had this on this date. Were you there? Did you witnessing the transferring physically of this document from party A to party B? And did party B take it in his hands? In what capacity were you there on? No, it's just a... So what does law say? Negotiation, transfer, and delivery. They didn't say an electronic record, but unless you dispute it, all right, it's accepted as truth. An unrefuted affidavit stands as truth. So what we need to do is to get the facts out onto record. What you think you're talking about and what you are talking about are two different things. And the court, again, they only opine on what you bring them. So when you bring them half an argument, you get half an answer of what you wanted. And many of the cases that are being decided, it's because of the half argument that was brought. When you look at Merz versus Edelson, when you look at Asgard versus Johnson, these are good cases, but they only had half the argument. You know? If you only have half the argument, if you're going to say, you know, where you're asking, does the banks, you know, do they have standing to invoke jurisdiction of the courts? You know, they're asking, you're asking, do the banks have they acquired standing? Have the banks been injured? No. There's a difference between a claim to title with legal rights incurred versus color of title, in which you would have simple possession of a tangible promissory note. Again, simple possession is not the same as legal possession with rights in accordance with law. Bank of America or JP Morgan Chase coming forth and claiming that they have the original piece of paper, when Bank of America purchased the assets of Countrywide Home Loans, right? They purchased millions and millions of documents that were in thousands and thousands of boxes. Now, those boxes at one time, all right, those pieces of paper being called tangible promissory notes, once evidenced, all right, obligations, intangible obligations. They evidence the debt. All right, now, that debt was sold. Now, the instrument goes to Article 3. All right, it's a negotiable instrument. But coming back 10 years later and just waving a piece of paper, all right, you have simple possession, mechanical possession, not legal possession with legal rights incurred. So when you're coming forth and saying, I'm coming to enforce the mortgage, well, let's see, you stripped off the debt, so that tangible promissory note no longer evidences debt. All right? Now, that security instrument cannot attach itself to the note because the debt is gone. With the debt gone, there is nothing to attach to. Your mortgage becomes a nullity. At Carpenter versus Logan, all right, a mortgage follows the note. Correct. A properly secured. Properly secured. Not a willy-nilly notion. Well, we're going to do an assignment. We've got a blank endorsement. We're good. No. You've acquired rights to enforce collection on the note. You have not acquired rights of enforcement. Now, if I were to look at 18 U.S.C. Chapter 47, 1021, which states anyone who knowingly records or does not record a document pertaining to real property could be found guilty of a felony for up to 5 years imprisonment. It is not the assignment which is fraudulent. It's the act of recording an illegal transaction. The act of recording that document, that's what was wrong. When you look at, give me a second, let me show this. And this is, again, what I'm talking about specifically, in this case, Florida, because I just happen to have Florida up here right now. Let's take a look at this. I apologize for jumping around, but we're talking about what has happened. So we're in Florida, and this is under Chapter 817, Fraudulent Practices. Part 1, False Pretenses and Frauds Generally. Unlawful filing of false documents or records against real or personal property. File means to present an instrument for recording in an official record or to cause an instrument to be presented for recording. Okay, so we've talked about the purpose of an assignment of mortgage to memorialize the transactions pertaining to the negotiable instrument, tangible promissory note. It did not cause the sale, nor the acquiring of rights. That would have been done through negotiation, transfer, and delivery of the note with a named payee. So in an assignment from MERS, transferring beneficial interest in a deed of trust, all right, well then, okay, with an as of yet named party, there is no agency principal relationship. And we can look under agent principal doctrine, right? We have, as a matter of fact, give me 1 second. Let's see what this is. This is Harvard Law School. Okay, and I just happened to, again, the research is done. And let's go. Here we go, table of contracts. The undisclosed, page 29. The undisclosed principal problem. So let's go to page 29. 21. Okay, so again, I didn't write this, it says here. The undisclosed principal problem, this is from Harvard Law School. The undisclosed principal problem arises when an agent makes an agreement with the third party who does not realize that the agent is acting as an agent rather than on his own behalf. The question then arises whether the third party has a legal claim against the principal as well as against the agent. again, I don't make stuff up. It's too funny. They make this up. This is what is being done. So I'm trying to explain and break this down into bite-sized pieces because this is an elephant. And how do you eat an elephant? We eat an elephant one bite at a time. So our investigation lays a foundation for declaratory judgment for a suit to quiet a cloud on title with the rescission of an assignment of mortgage or an assignment of deed of trust that was ineligible to be recorded. Again, what we do is an example sample. Because
welcome to Verizon Wireless. The wireless customer you called is not available at this time. Please try your call again later. Announcement 1, switch 59-2.
Please mute. Thank you. Please mute yourself. Thank you. Okay. So again, there are statutes out there. So what we need to understand is everything that we do is statutorily. The defenses are statutorily and facts are made. So when we're looking at, again, the infographic, what was to happen? Now, we have infographics created for Fannie Mae, Ginnie Mae, Freddie Mac, trust with sponsors, depositors, trust without depositors, only sponsors. So 90% of the time when we do a chain of title investigation and analysis, you will receive one. There are some instances, though, that we do not have because it's so complicated, it would cost thousands of dollars to come up with the time and effort to put into it. Hundreds of hours have been put into this. Like, you know, again, we've got about 30 different versions out there that we use. So just so everybody is clear, if there is an instance where you are in a private trust and I have no PPM, which is a private placement memorandum or a prospectus, which gives me the information that I need pertaining to transactions and dates and everything, then I do not always have an infographic to create for you. However, 90% of the time when we do our educational package, we do have one to show you. Now, let us go into as well, take a few minutes and give me a minute, please. Let's just do this. Closing a bunch of windows, so I apologize for the delay. All right. We haven't had a chance to even get into, a number of people are asking, Joe, I'm going to go real quick through an investigation. Any questions that you have, because of our time and delay in starting today, if you can email them to us, that would be wonderful. So we will show you our email address when we're all done here. So again, I apologize for the delay in getting started, and our meeting is going to end in a little while. So I would like exactly our investigation consists of, because it's unlike any other. Again, this is the most in-depth information that you're going to get. So our table of contents explains the different sections and how they're used. Section 1 says, Intro to Conveyance of a Securitized Mortgage Loan. So we go into elements of a mortgage loan instrument. What got securitized? Talk about personal real property rights as a transferable record. What should have happened? What did happen? Conveyance of an E-note. None-holder in due course alleges default. Again, this is information which is written in layman's and legalese. Section 2, we're going to talk about the mortgage loan transaction history. Again, depending on the parties to your transactions, everyone will change. Section 3 is infographics. Section 4, again, depending on if it's applicable, New York trust law, information on endorsements. So these are the contents of our package. So we start out, Here we go. Section 1, conveyance. So this is explaining, defining the definitions. Tangible promissory note, a writing in tangible form, signed unconditional identifying an indebtedness or an unsecured promise by one party. Again, I'm not going to read the whole thing. So this is as clear and as concise as you can get. Now, the first 7 pages of the educational package pertain to everyone. And I would suggest that you get a cup of coffee and you sit down, because when we complete your analysis, it's going to range from 30 pages to 45 pages, depending on the information, depending on the documents that we are provided with. Based on the documents that we're provided with and what has happened to your documents will be the basis of the investigation and analysis. If you have a note that has been evidenced by a third party, being either the bank or the plaintiff in a complaint, or you've done a QWR or an ERIR letter, right? That gives us more ammunition in which to prepare our analysis. This analysis is to educate you. This analysis can be used in conjunction with an affidavit of fact that we do. The affidavit of fact that is done backs up my findings in this chain of title, analysis and investigation. All right, so again, we're still on Section 1, conveyance of a securitized mortgage loan. So again, I'm giving you the most pertinent information that you can find. All right, it does not leave anything to the imagination. This is not a quick read. We talk about what was supposed to happen. We talk about what did happen. Okay, again, it goes into detail. We talk about e-notes. I touched on it a little bit. So we go into complete detail as to what is an e-note. What are we talking about? Electronic notes, electronic mortgages, electronic sales. So this is why we need to understand exactly what is the investigation, what is the chain of title. So when you read this, again, this is the most complete and concise information that is put out there for the client, being either an attorney, a third-party nonprofit organization helping clients, a group such as a foreclosure defense group helping neighborhoods stay intact. Again, this information is for all. We include it with every educational package. Okay, so when we get into Section 2, again, we put information in here. We do a public record search, and I look at all the documents that have been filed into public record. Every single loan that I look at, I'm going to pull a public record. If you could mute yourself, that would be nice. Thank you. Somebody still has their microphone on. I can hear them. Can everyone please make sure that you are muted? Thank you. So again, depending on your mortgage loan transaction history, the information changes every time. So whether you're with a GSE, an RMBS, here's the information for this particular one for an RMBS. It shows the classes. It shows where was it found. Okay, Section 3, we talk about the infographic. It explains a little bit about the infographic. The chronicle or paper trail. What was to happen, what did happen, or what did not happen. As we had talked about, if we are able to do an infographic, this is where the infographic will be. This one is for an RMBS. We also have them for GSEs. It just depends upon your unique situation. This is an overview. You blow this up, take this into court. The judge is going to look at you and open up. What do you mean this is what to happen? What do you mean this is what they did? And you can back it up. And we also put the information where it says, see paragraph 1 in the analysis. We're given the information where we're shown in this particular instance where it has been bifurcated from the intangible with the tangible, and they've been separated. Here, see paragraph 10. So depending on your situation, would depend on the information, again, that we're able to put in here. I'm talking here, we have assignments. Here it says, see paragraph 29. All right, so in here, see paragraph 29 in the analysis. Here's the date. See paragraph for the analysis. So in those paragraphs, gives the information which shows what were the transactions that this is talking about. Again, this is given in a concise format that a layperson, an attorney, and a judge can follow. The reason it's done in an educational analysis because conclusionary information is given, opinions are given, citations are given. All right? Now, if I was to educate you in your understanding of this, and you as a homeowner or as an attorney now have firsthand knowledge of the information of that I am giving you. This information, again, is then backed up by a factual affidavit. So I talk about, here's the documents that I've looked at. So I state all the documents that I'm looking at. Again, depending on your case, some instances all I have to work with. Other times I have a note, a mortgage, 4 assignments. So again, documents are 4. When you get the factual affidavit along with this educational analysis, it can be entered into court and I can be called to testify as either a factual witness or an expert witness. And yes, this month I'm testifying in Florida in 2 cases, I believe, or 3 for this month. I have a case in Wisconsin I'm testifying in February. I have a case in Jersey I'm supposed to testify in November. So I back up what I say. When we talk here, again, we're actually getting started on this one on page 15, where I talk about what were my findings. So I go through here and I talk about researched. And then as I go through it, what did I find? Right? When we talk about the trust, we talk about, again, these are facts to be done. Right? What are the cases? We talked about UEATA. As explained previously, any electronic transfers of the Doe Deed of Trust that may have been executed without recording within the official records of Orange County Register are void under Uniform Transactions Act, UEATA, USC 15-97-7003. And then below that is an excerpt from that statute, which states, accepted requirements. The provisions of Section 7001 of this title shall not apply to a contract or other record to the extent it is governed by the Uniform Commercial Code, as in effect in any state other than Sections 1-107 and 1-1206 and Articles 2 and 2A. All right, so the tangible promissory note falls under Uniform Commercial Code, Article 3. Your deed of trust or mortgage falls under local laws of jurisdiction and state law. UEATA does not follow any of the documents pertaining to real property, again, as they pertain to the Uniform Commercial Code. So depending on, again, what we find in your documents, in this particular case, there was a pool and servicing agreement. And I searched the pool and servicing agreement, and in this particular instance, I tell you what page I found the information. As stated on page 39 of the pool and servicing agreement. Here's the date, August 17th, section governing law. Now, the purpose of the information, all right, is to give credibility to what we are saying. It does not make you a party to the pooling and servicing agreement at all. The fact that the party is coming forth claiming that they've been injured, claiming that they've acquired rights, well, if you've acquired rights, then you've acquired rights according to your pool and servicing agreement. In your pool and servicing agreement, it says you would do this. You're saying you followed law, so let's just ask the courts to see, did he follow law? Was everything done in accordance with law? That's all I'm asking. No, I wasn't there, but that doesn't mean that you cannot not follow law. Again, here we have an assignment, and this information that you're looking at was taken directly out of the VLR, which is a voluntary liens report that we do for every client. Again, an exception is made in some of the northeastern states, such as Upper New York. We are unable to pull voluntary lien reports, and again, probably 90% of the time we are, but there is the occasional time depending on what the requirements are for your county recorder's office. Some of these small townships we are not able to get in, and this is why we ask when you provide us documents that, you know, we give you a list and we ask that you follow that list. There's a reason for the information that we ask. You know, if I ask for a social security number, there is a reason for it, because I need access to databases. I need access to make sure that this information belongs to you. MCI created this package. We did not take off any other company's products that were put out. These belong to MCI. The investigations are done by licensed private investigators. So the information that we put here, again, yes, we give citations. If the attorney or the homeowner wants to use the citations, that's fine. As an analysis, I am giving my opinion. This is how I've come to my conclusion. It is an analysis. My affidavit of fact is an affidavit of fact. So again, as we go through this, the more information we have, the more we're able to get into it. Again, we're talking here about the Doe Deed of Trust having Covenant 16, and we went by this earlier. Okay, so again, we get into Section 4. It depends. In this particular case, we got into New York law. It just depends on the particular situation. So I know it was a crash course today. I hope that everyone has enjoyed it. Give me 1 second. Oops. Apologize for that. What I would like, if anyone has any questions, to email us. Again, we went over our time. It's a little after 1 o'clock already, and we could still have more information to cover. But the point that I was hitting on today is that simple possession of an Article 3 negotiable instrument pertaining to real property, being a tangible promissory note, all right, secured by a security instrument, being either a mortgage or a deed of trust, or if you're in Georgia, a security deed, all right, simple possession of that negotiable instrument, all right, is an illusion that they've acquired rights to enforce foreclosure. It's a big illusion, and when you understand that, all right, it makes it a lot easier. So again, the illusion is that I have this, all right? It's a blank endorsement. Okay, so what? Just because you have a blank endorsement with rights to collect on the note, they do not extend to the rights to enforce a security instrument to an as of yet unnamed payee because of a lack of agent-principal relationship, rights acquired in accordance with law. And this is where, again, we're thinking outside of the box, or before you go into your quiet title complaint, again, look at, possibly an example sample of a declaratory judgment to quiet a cloud on title with rescission of an assignment of mortgage that was ineligible to be recorded. When you look at that, before inviting everyone to a quiet title party, because a declaratory judgment, all right, does not, it's a standalone action. You're asking the courts to make a determination as to status quo of parties with a color of claim title. So we'll have another webinar and possibly in a couple of weeks, and if everyone can email mortgage compliance investigators at info, at mortgage compliance investigators with any questions that you have. We'd like to send you a newsletter, keep you up to date as to what we're doing, any articles that I've written, and we're welcome to take any of your phone calls again during the week. And I look forward to talking to everyone. I hope everyone has a nice day, and thank you very much.